Hey, welcome to the podcast.
Thanks for having me, man.
So I was reading about this civil law stuff, and I gotta ask you, what even is a civil claim? Like, the overview section is way denser than I thought it'd be.
Right? Okay, so basically, the material says up front it's given you an overview of civil dispute resolution, not like a step-by-step walkthrough, you know?
Wait, so civil dispute resolution, that's basically any court case that's not criminal, yeah?
Exactly. So criminal is the state going after someone, right? But civil is different. It's two private parties going at it, like a claimant and a defendant.
And claimant is the one bringing the case and asking for something, usually money, yeah?
Yeah, they're asking for what's called a remedy or relief. Most of the time it's money, but not always. Could be custody stuff or like challenging a government decision or something.
Okay. So give me some real examples. What kind of cases fall under this?
Dude, it's huge. Breach of contract, someone gets hurt and sues, professional negligence, property disputes, intellectual property, divorce stuff, custody battles. Like, the list goes on forever, which is why the material keeps saying how varied it all is.
That's insane. So how does the whole thing actually start? There were stages mentioned, right?
Yeah, so there's like this flow chart in the material: pre-action, then statements of case, case management, evidence, trial, post-trial. And then you've got interim applications and appeals happening alongside all of it.
Pre-action. Is that like trying to work it out before you actually sue someone?
Exactly. So the parties are supposed to try to sort it out without going to court. There are rules for how you exchange information, way less formal than actual court documents, but it matters because it saves time and money.
Oh, because litigation is just expensive and takes forever, right? The material keeps hammering that point.
Totally. It's time consuming, it's inconvenient, it costs a ton, so they really push negotiation or mediation first.
But if you do end up in court, what's the next step? Statements of case?
Right. The claimant files the claim form with all the details, and then the defendant responds. They can admit it, deny it, or counterclaim. That's where the actual dispute gets defined.
And those documents are like super important to the whole case, right?
They're everything. Those statements of case define what's actually in dispute, what both sides agree on, and what the judge has to decide.
Okay, so put it simply, they basically say what the judge needs to figure out, yeah?
Exactly. The judge decides the facts that aren't agreed on, then applies the law to those facts, and that's how they decide what relief to give.
Okay, give me that car accident example you were going to mention.
So, the claimant says the defendant pulled out negligently, hit them, caused a neck injury, all this treatment, ongoing problems, and they lost $5,000 in income. So they're asking for $25,000. The defendant admits the crash happened, but says no way they were negligent, and they don't know about any injury.
So now the court has to figure out, was the defendant actually careless? Did the claimant really get hurt? Did they actually lose that money?
Exactly. And that's where the evidence stage comes in. They exchange documents, get witness statements, maybe expert reports to prove what actually happened and what the injuries are.
That sounds expensive as hell. How does the court keep it fair and not let it blow up?
The court actually manages it actively. They put the case on a track: small claims, fast track, intermediate, multi-track, depending on how complicated it is and how much money's involved. Then they issue a directions order.
What's a directions order exactly?
It's basically the court saying, okay, here's your timeline. You got to exchange documents by this date, witness statements by that date, expert reports by then. So by the time you get to trial, everyone knows what the other side is arguing.
Okay, so the court's basically keeping everyone on track and making sure nothing gets crazy.
Right. And if something urgent pops up before trial, you can ask the court for an interim order, like you need something right now.
So after trial, if the claimant wins, what happens? They get paid?
Yeah, the court orders payment and costs. But if the defendant doesn't pay, then the claimant has to enforce it. They can seize stuff, sell it, all kinds of options.
And the losing side can appeal, right?
They can, but honestly, the grounds are pretty limited. It's not like you can just appeal because you don't like the outcome.
Reflective. So throughout this whole thing, can the parties still try to work it out, like mediation or negotiation?
Absolutely. The material keeps stressing this. You can try alternative dispute resolution at any point, and if you reach a deal, you're done. Saves everyone time and money.
Perfect. All right, that actually makes sense now. Thanks, this was really helpful.
Anytime, man. Seriously though, try mediation first.
Your wallet will definitely thank you. And read those directions orders carefully. They matter.
They really do.